The class action application was brought on behalf of hundreds of car owners by a Port Elizabeth law firm. Judge Dale Chetty ruled that there were no grounds for a class action. He said the applicant's case was based on conjecture and assertions with no facts for the assertions. Bad news for those who took part in the scheme.
I don't want to give my car back, I need it. But I can't pay over 3,000 rand for a little Tata Indica. I don't earn that amount of money.
Judge Chetty said there were suggestions that the involvement of Duncan Ewer, the legal representative in the litigation, was purely altruistic and that he had been the initiator of the litigation.
We respect the decision of the court. Unfortunately, we have been unsuccessful with certifying the consumers as a class for the purpose of bringing a class action on behalf of the consumers. This means the consumers will unfortunately have to resolve their matters individually. Our firm's intention from day one has been to assist the consumers, and we shall continue to do so in any way we can.
The scheme worked with the consumers signing two contracts, one with the bank for finance, the other with the Satinsky Group, where they were offered a rebate for advertising on their cars. Vehicle owners will now have to pay the full monthly instalments to the banks that supplied the finance. The other option is to litigate against the banks on an individual basis. If they refuse to pay, their cars will be repossessed. The scheme collapsed earlier this year. Janine Lee, SABC News, Port Elizabeth.